When the people nominated to uphold the law can't even say they'll follow it, that's not hesitation. It's a constitutional red alert. What unfolded in that Senate hearing wasn't confusion or nerves. It was something much more dangerous. Within seconds, a calm and methodical questioner turned a routine confirmation into a national stress test for democracy itself. And as each nominee fumbled through what should have been the easiest question in the world, you could almost hear the foundation of legal accountability start to shake. The IT started with a simple challenge. Would you ever advise the administration to ignore a court order? The question sounded harmless, almost academic.
And make sure that your answers are as definitive as they sounded. So let me start with you, Mr. Edlow. Yes or no? Would you ever advise the administration that it could ignore or disregard an applicable district court order because you believe the Supreme Court will ultimately overturn it?
Senator, as I said before,
yes, just a yes or no question.
I don't believe I'll ever be
Senator,
in that position.
But you may not. But just like you answered Senator Kennedy, I want to make sure that you were not misleading anyone. So let me ask the question again. Would you ever advise the administration that it could disregard an applicable district court opinion or order because you believe the Supreme Court will ultimately overturn it? Yes or no?
I don't want to speculate, but I can't see a situation where I would advise to not follow a court order.
So your answer is no, you would never advise them to disregard a district court order, even if you thought the Supreme Court
Again,
would
I don't want
overturn
to speak.
it.
I don't want to speak.
I just want you to be precise and answer yes or no.
I can't see a time where I would do that. No.
Okay. Mr. Geiser, yes or no?
Thank you very much, Senator Schiff. I would advise clients to follow court orders.
Even if you believe the Supreme Court would ultimately overturn the district court?
Well, Senator, as far as
yes or no?
The answer is the same. The president has said he will follow court orders.
The same answer, yes or no?
Senator, the president has said he will follow.
You were able to answer Senator Kennedy, but I want to make sure that you were not misleading Senator Kennedy. Yes or no, would you ever advise the administration it could ignore a district court order because you believed the Supreme Court would ultimately rule otherwise? Yes or no, would you ever advise them that?
Senator, applicable court orders should be followed.
That's not my question. Yes or no?
Senator, you asked me.
Yes or no, Mr. Geiser? It's a simple question.
Senator?
Mr. Geiser, you were able to answer Senator Kennedy. Are you raising a doubt now about your answers to Senator Kennedy because you can't answer this question?
Senator, I would advise clients to follow applicable court orders.
Is that a yes or no?
I would advise clients to follow applicable.
Is that a yes or no? Let me repeat the question so there's no ambiguity about it. Would you ever advise the administration, you're going to be, if you're confirmed, heading the Office of Legal Counsel that helps determine whether actions are lawless or lawful, would you ever advise the administration that it could ignore an applicable district court opinion or order because you believed the Supreme Court would ultimately overturn the order? Yes or no?
Senator, if I'm confirmed to lead the Office of Legal Counsel,
all right.
I would.
You're not answering the question. So I guess the answer is to Senator Kennedy, you just might advise the administration to ignore a district court order. How about you, counsel?
Thank you, Senator Schiff. In my role as director, I
just
am not
asking yes or no.
Well, I would thank you. I wish to clarify. I'm not, if confirmed, a director. I'm not acting in a legal capacity at all. I'm part of the executive agency branch, and therefore would not be advising clients on any aspects of that.
Well, would it be appropriate, in your view, for anyone else among legal counsel to do so?
In general, court orders should be followed and respected. There are situations which I recall back from law school between branches.
I guess you're not able to answer the question either. Counsel, how about you?
Senator Schiff, thank you. I mean, I agree. I don't believe it's appropriate to address this hypothetical. At the Department of Justice,
so you want to revise your answer to Senator Kennedy then? That is, there may be circumstances where you advise the administration to disregard a district court of opinion because you believe the Supreme Court might rule otherwise. Is that your opinion?
As a lawyer, the answer is it depends.
Okay. Thank you. Then we'll make sure Senator Kennedy is aware that you just might, it depends, advise the administration to ignore court orders.
Senator,
let me ask another question. Mr. Geiser, would you agree that it would be unlawful for the president to accept a gift from a foreign state without the consent of Congress? Would you agree that's unlawful?
Well, thank you for that question, Senator.
Yes or no?
Whether something is lawful or not, I would always want to look.
I'm just asking you a simple question. Is it unlawful for the president to accept a gift from a foreign state without the consent of Congress? Very simple question.
Senator, as a lawyer, I would always give my...
I'm not asking you for a preamble, just yes or no.
Well, Senator Schiff, it depends on the fact...
Well, Mr. Geiser, where is the depends on the facts of Article 1, Section 9, Clause 8, which says, no person holding any office shall, without consent of Congress, accept any present from any foreign state. That's the Constitution. Doesn't say, well, it depends, or it might, or maybe. It says, no person shall do so. Do you find that ambiguous?
Senator,
I thought you were supposed to be the strict constructionists. This is what the Constitution...
But the silence that followed told the real story. One nominee paused, stumbled, and tried to drown the moment in legal language. Another hedged with a, well, it depends. They couldn't commit to the most basic rule of American law, that no one, no matter their position, can place themselves above the courts. And watching it unfold, Adam Schiff wasn't just exposing them. He was exposing the creeping mindset that law is optional when it's inconvenient. Schiff's tone didn't rise. He didn't need to shout. Instead, he pressed calmly, surgically, forcing each nominee to either stand with the Constitution or twist themselves into knots trying not to. Every long pause, every lawyerly dodge spoke volumes. These weren't random appointees. They were being considered for the top legal posts in the nation. The people who would shape how executive power is interpreted, how far it can reach, and how much it can bend before it breaks. And one by one, they couldn't even bring themselves to say the word no. That moment wasn't just embarrassing, it was revealing, because it showed how loyalty can quietly replace legality. Schiff's questioning stripped away the political polish and exposed what lies underneath, a willingness to treat the law as flexible when it suits the powerful. You could see it in their expressions, the split-second calculation of how to protect themselves without crossing the man who nominated them. But what none of them seemed to realize was that the refusal to commit to the rule of law is, in itself, an answer. The exchange turned almost theatrical, but not in the way hearings usually do. Schiff's yes or no questioning style turned the spotlight inward. Would you ever advise the administration to disregard a district court's ruling? Simple, direct. But as each nominee dodged again and again, repeating the same empty phrasing, I would advise clients to follow applicable orders. The illusion of competence started to crack. These were supposed to be the nation's most trusted legal minds, yet they were dancing around the core promise every lawyer swears to uphold. You could feel the tension grow. The more Schiff pressed, the more it became clear this wasn't about the question. It was about the answer they were afraid to give. Because saying yes would expose them. Saying no would distance them from the power structure they wanted to serve. So they chose a third option: fog, hesitation, and plausible deniability. And that was exactly the moment Schiff pushed the conversation to its breaking point. He pivoted from hypothetical to constitutional. Would it be lawful, he asked, for a president to accept a gift from a foreign government without Congress's consent? It's one of the clearest rules in the entire Constitution. There's no footnote, no wiggle room. The answer should have been a simple no. Instead, the nominees froze again. One tried to lawyer his way around the question. Another claimed, well, it depends on the facts. Schiff didn't flinch. We're in Article 1, Section 9, he asked. Does it say that it depends? He quoted the clause word for word. No person holding any office shall, without the consent of Congress, accept any present from any foreign state. Not sometimes, not if convenient, just no. Yet even with the text right in front of them, they couldn't give a direct answer. It was surreal to watch. The Constitution, in black and white, met a wall of gray. And Schiff's calm persistence exposed something more alarming than any headline. Because if those who interpret the law for the executive branch can't commit to following the plain language of the Constitution, then who can? What happens when the legal advisors meant to serve as guardrails become enablers instead? That's the deeper story beneath the surface. The Office of Legal Counsel isn't supposed to be a political weapon. It's meant to be the conscience of the executive branch. The OLC's job is to tell the president what can and cannot be done under the law. But what Schiff uncovered is a new culture of compliance, not with the law, but with the person in charge. These nominees weren't auditioning to uphold justice. They were auditioning for loyalty. Their words weren't legal reasoning. They were political positioning. And Schiff's technique, insisting on yes or no, wasn't just a rhetorical move. It was a moral test. Because the rule of law isn't a spectrum. Either you follow it, or you don't. Either court orders are binding, or they aren't. Either the Constitution means what it says, or it becomes a menu of optional guidelines. When nominees can't answer that clearly, it signals something deeper than political alignment. It signals the corrosion of principle. Imagine a system where the people who interpret laws begin to see them as suggestions, where every decision is filtered through political interest rather than legal merit. That's not a democracy anymore. That's rule by permission. Schiff's exchange peeled back the curtain on that slow transformation. Each dodge question wasn't just an awkward moment on Capitol Hill. It was a small surrender, a micro crack in the wall separating power from law. And it's not just about one hearing. It's about what these moments represent. Because once officials start deciding which court orders to obey and which to ignore, every other line in the Constitution becomes negotiable. The principle of checks and balances begins to erode. Judicial authority weakens. The executive grows bolder. And slowly, the meaning of law itself changes from something universal to something conditional. Schiff seemed to understand that perfectly. His calm frustration wasn't about scoring points. It was about warning the country. He reminded everyone that obedience to the law isn't optional. It's foundational. When those entrusted with upholding it start dodging, the entire system begins to tilt. His line of questioning made that visible in real time. One official at a time, one it depends at a time. The very idea of accountability starts to blur. The brilliance of the exchange wasn't in its drama, but in its precision. It didn't rely on outrage. It relied on exposure. Every pause, every avoidance, every carefully chosen phrase showed viewers the difference between defending the law and defending power. Schiff didn't need to accuse anyone of corruption or partisanship. The nominee's own words did that for him, by the time he asked the final question about whether they found the Constitution ambiguous. The pattern was undeniable. Each nominee had failed the same test, the ability to give a direct answer about the most direct principles of governance. And in that failure, they revealed how fragile the rule of law can become when political convenience overrides clarity. For anyone watching, the implications were chilling. Because what happens in these hearings doesn't stay in the hearing room. These nominees, if confirmed, would shape the legal boundaries of the next administration, deciding whether to obey court rulings, how to interpret congressional oversight, and how far executive privilege can stretch. Their hesitation wasn't just about legal caution. It was about setting a precedent for selective obedience. That's why Schiff's exchange matters far beyond Washington. It's a reminder that democracy isn't only threatened by loud assaults from the outside. It's weakened quietly, through small acts of silence on the inside. When those who swear to uphold the Constitution can't bring themselves to say they'll follow it, the system doesn't need to collapse. It simply stops holding. And for viewers across the country, this hearing became something unexpected, a mirror. It reflected not just the flaws of a few nominees, but the slow normalization of double standards. It asked an uncomfortable question. Do Americans still expect the law to apply equally, or are we getting used to watching it bend? Schiff's approach forced that reckoning. His insistence on clarity stripped away the comfortable ambiguity of politics and left only truth, or the absence of it. Watching those nominees squirm under such a basic question was like watching a moral MRI scan. Every evasion revealed a hidden fracture in the system. But perhaps the most striking part wasn't their hesitation. It was Schiff's composure. While others might have turned the hearing into a spectacle, he let the silence do the talking. And that silence said everything. It said that the legal system is being tested not by extremists outside it, but by officials inside it who have learned to speak the language of the law while undermining its spirit. That's the story this moment tells. The quiet, dangerous drift from constitutional duty to political obedience. And once you see it, you can't unsee it. Because every "I can't speculate" and every "it depends" isn't just a phrase. It's a symptom of something deeper. The belief that accountability can be negotiated, that's what makes this hearing so important. It wasn't just about who gets confirmed. It was about who still believes in the boundaries that make a democracy work. It showed how fragile those boundaries are when people in power start treating them like technicalities. And it left a haunting question in the air. If obeying a court order is no longer automatic, what else might soon be optional? Schiff's quiet persistence gave viewers a rare gift: clarity. The hearing wasn't dramatic in the Hollywood sense, but it was historic in the civic sense, because it turned the spotlight on something invisible but vital: the integrity of those who interpret the law. It revealed how democracy doesn't die with a bang. It fades through 1,000 evasions. For anyone paying attention, this was more than a political exchange. It was a warning that the next erosion of rights won't come with fanfare. It will come with polite hesitation, carefully worded statements, and just enough ambiguity to sound reasonable. That's how guardrails disappear, not with defiance, but with deference. And that's why this moment should stay in public memory. It wasn't about personalities, it was about principles. It showed that the most dangerous threat to the rule of law isn't chaos, it's compliance with the wrong things. Because once obedience to power replaces obedience to the Constitution, everything else becomes negotiable. So if this hearing seemed tense, it's because it wasn't just about the nominees. It was about us, about what kind of country we're willing to be. A nation where law means something fixed, or one where it bends to whoever holds authority that day. Schiff's questions drew that line in real time, and the answers, or lack of them, made it clear which side some have already chosen. This was more than a hearing. It was a glimpse of the struggle between principle and power, fought not with shouts, but with silence. And that's why it matters. Because democracy doesn't collapse overnight. It erodes in daylight, while everyone's watching, wondering if maybe it's not that bad, but it is that bad. And it's why every American should be paying attention. Because the next time someone in power hesitates to answer yes to obeying the law, that hesitation might cost more than anyone expects. If you believe these moments deserve the spotlight, if you want more breakdowns that expose what really happens behind political doors, make sure you subscribe, like, and share. Stay curious, stay skeptical, and most of all, stay engaged. Because the rule of law only survives as long as we demand it to.